It is really always awesome to get to work with you all at Cooper Square and the amazing tenant leaders who are organizing in their neighborhoods. I'm glad that we'll be spending the next hour or so together. My name is Mike Grinthal. I am a housing lawyer at an organization called TakeRoot Justice. I've been a housing lawyer in New York since 2007, so I've seen a lot of the changes in the law since then. And I can say that the new good cause eviction law is one of, if not the biggest changes in landlord tenant law and housing law that we've had in the time that I've been here. I'm going to try to share my screen and hopefully that will work. All right, so hopefully you are looking at um, the first slide, which should say Introduction to Good Cause Eviction Law. If somebody could just throw me a thumbs up just to let me know that that's working. All right, great. All right. Um, so we're going to talk about the good cause eviction law, but before we get started getting into everything that the law says, I just want to give some background about it. As folks may know, it was passed by the legislature in Albany almost exactly a year ago, and immediately went into effect in April 2024. It was passed because of years of work by the tenant movement, including Cooper Square Committee and maybe some of the folks on the call tonight. Um, when it was passed, there were a lot of last minute rewrites and compromises, which results in the law being, in some places, a little bit odd, a little bit awkward to use, definitely complicated, and with a lot of unanswered questions about how the law is going to shape up as judges in housing court make decisions around it. So that's going to be a refrain tonight of me saying, we don't yet know how this is going to play out, which is another way of saying we still have the opportunity to influence how it plays out. How it plays out is going to be the result of what tenants and landlords do in their battles in court, uh, and what we do when we talk to our state representatives. Okay, so TakeRoot Justice, the organization I work for, we're a nonprofit legal services provider. We provide legal participatory research and policy support to grassroots community groups like Cooper Square Committee, um, that are working to dismantle racial, economic, and social oppression. So tonight we are going to go over the basics of the good cause eviction law. And first, what does it do? Second, who does it cover? Who does it do those things for? Third, when did the different parts of it take effect? And then finally, how we can use it, both ourselves and our neighbors and other people in our communities. As we go, if folks have questions, please put them in the chat if you're able. If the device you're on doesn't let you put things in the chat, if you can put up your hand electronically, that would be great. If there are questions that are clarifying questions as we go, I'll try to answer those in the course of things. If it's a longer question, then we will get to it at the end when we do a question and answer period. Right. So what does the good cause eviction law do? It does two main things. Right? For people who are covered by it, it prohibits no cause evictions, right? If you're unregulated, your landlord can say, when your lease is up, I don't feel like renewing your lease. And they don't have to have a reason. It doesn't matter whether you did anything wrong, whether you paid all your rent. In unregulated apartments, landlords can evict people without cause. But if you're covered by the good cause eviction law, a landlord can no longer evict you or refuse to renew your lease without a cause. And we'll get to what what the causes are under the law. The second thing the law does is it puts some limitations on rent increases, how much a landlord can raise the rent each time they renew the lease. And if you're familiar with the rent stabilization law, you'll notice this parallels rent stabilization, which does both of these things. It prohibits no-cause evictions in rent-stabilized apartments, and it limits rent increases. So what does the law mean by good cause? Um, if you're familiar with the rent stabilization code, you'll see this is almost exactly the same list as for rent stabilization. So a tenant can be evicted for breaching their lease, for committing a nuisance, which is conduct that tends to harm other people or threaten people's safety, for illegal use of the apartment, for example, using an apartment as a commercial space, or committing illegal activity in an apartment, denying the landlord access for necessary repairs or inspections, and then two causes that are actually not based on the tenant's conduct. The first is if the owner intends to move themselves or an immediate family member into the apartment to use as their home, their primary residence. They can, that's a basis for them to refuse to renew a lease. Again, that parallels rent stabilization. And then finally, if the landlord is going to demolish the building or turn the unit into something else. And then, unsurprisingly, non-payment of rent is a basis for eviction. As for limiting rent increases, um, this is the first part of the law that we're going to come to that you can tell that it was the result of a compromise somewhere around 1 in the morning, the night before the legislature voted on it, because it's complex and probably doesn't make either side happy. So when a landlord renews a lease, they can increase the rent by what's called the local rent standard. And that is 5% plus the annual change in urban consumer price index, which we all know what that means. No, we don't know what that means at all. But it is a measure of inflation that the federal government publishes, and it changes every year. To make it a little bit simpler, DHCR, the Division of Housing and Community Renewal, which is a state agency, has to every year publish on their website what that is. So you can look it up and see what the local rent standard is. For 2024, it was 8.82%. And they should be updating that soon because we've just passed the 1 year anniversary. And so since that's indexed to inflation, uh, it matters a lot what's happening in the economy. And so, for example, if Trump's tariffs drive up prices, that will be reflected when the federal government publishes what the inflation rate is, and landlords will then be able to increase rent by more. So the bottom line is this produces a number that you can find on DHCR's website by searching local rent standard, and it says how much the landlord can increase the rent this year. But there is an exception. Landlords under the law can actually impose a higher rent increase than that. And the law says that can be proper. And it generally considering if the landlord had unusual expenses that year. And the law lists a lot of things that could count as unusual expenses, but it doesn't really give much guidance about how to calculate these things, how much of an expense is enough to justify a rent increase, how unusual they have to be. But the law says that it can be based on fuel or utility costs, insurance, maintenance or what they call significant repairs, which is replacement of building systems, right? So if they do an overhaul of the plumbing or they replace the roof, or abatement of hazardous materials, lead, asbestos, and mold. Uh, what's especially difficult about this is that if your landlord sends you a renewal lease and it's got a 15% rent increase instead of that 8.82, and they say it's because I had unusual costs this year, you can disagree with them, but there's no way to resolve that disagreement except to go to court. Now, under rent stabilization or rent control, the state agency, DHCR, you can go to them, you can file a complaint, and they will rule on it. And so you can get a clarification of how much rent you really need to pay, or whether you're rent stabilized or whether you have succession rights. DHCR doesn't, under the law, they don't have power to make decisions for good cause eviction law. So the way it will play out is if your landlord gives you that lease with a 15% rent increase and says, I had unusual costs this year, and you say, I don't want to pay that, I don't believe you that your costs justify this, uh, and so you refuse to sign the lease, then the landlord can take you to housing court for refusing to sign a lease. And then a judge has to decide whether that rent increase is justified. And unlikely that a judge could decide that without holding a trial. So it's not only going to court, but it's a really involved and long and potentially complicated and expensive way to go to court. And in order, the tenant has to risk eviction in order to go to court. And then on top of that, the law doesn't even really give the judges any guidance on how to weigh these different costs, and how to calculate what's a reasonable rent increase. And the only way that we're going to end up with any kind of formula or any kind of guidance is out of the collective effect of judges making decisions and then citing each other's decisions. And so very gradually, the how this law works will take shape in court, and it'll be based in large part on what happens, how tenants do in fighting rent increases. So far, there have not been any rulings that, at least that have been published or shared on this issue. So we're a year in and we still don't know what this means. Okay. Let's shift gears and talk about who is covered. Who does this apply to? Uh, and this has a number of moving parts. The first and simplest part is a landlord, if a tenant whose landlord owns more than 10 housing units. And that doesn't have to be in one building. It could even be 10 single family homes, as long as there are 10 units within New York State. So if you live in a building with 11 or more units, you are very likely covered, unless your landlord lives in one of those units in the building. If your building is fewer than 10 units, but you think your landlord might own other units elsewhere, this opens up a can of worms. So the way that the law tells you to count is, it's if your building is if the owner of the building is listed on the deed as a person, Joe Smith, then you count every other unit of housing that Joe Smith owns anywhere in the state. Plus, if Joe Smith owns other units elsewhere through a company, through a corporation, usually an LLC, those count too. If your building is owned by an LLC, then you look to the owners of that LLC. So an LLC is a corporation, a very small corporation, usually has one or two owners. And it exists really just to provide kind of like a shield between the person and the property. So it's common for landlords to form an LLC for each building they own, right? So that your building probably isn't owned by Joe Smith. It's probably owned by 123 Main Street LLC, which is then owned by Joe Smith. The bottom line is that you get to look through the LLC. It's not, they can't say, well, this LLC only owns one building. I started an LLC for each of the 20 buildings I own, and so you can't count them together. You count everything that's owned by any company that's owned by the same person, um, which is a good rule. That's how we want it to be because it's the maximum count. It allows us to get to 10 units. The difficulty is that LLCs, there's no place to look up publicly who owns an LLC. Uh, there's no requirement that LLCs publish who their owners are. And so if you look up on the state's corporation lookup website, your 123 Main Street LLC, um, it's going to give you some basic information about when it was first incorporated, and it'll give you a mailing address, but you won't be able to find out who is the human being behind it. And so that sets up what's going to be a major theme in how good cause plays out is this puts a big burden on tenants to do a lot of research and detective work to find out who owns their building and what else they own. And there is no single source of this publicly. We will come back to, at the end, some free public tools that can be really useful in doing this, as well as some tools that may come into existence from some new laws next year. But for the time being, again, uh, good cause probably applies if your landlord owns more than 10 units in the state, uh, whether they own it in their own name or whether they own it through a company. Now, if your landlord says, I'm a small property owner, meaning they have 10 or fewer units, they have to, in writing, tell the tenant, these are the units I own, right? So they have to disclose something. And they have to give that notice every time they say they're not going to renew a lease or say they're going to increase the rent or bring a court case, right? They have to say, you're not covered by good cause because I only own 8 units. I own 4 in this building and I own 4 in this other building. And that's not nothing, but it really does require the tenant to put a lot of trust in the landlord making a really self-interested statement. There's no reason that we should expect that landlords are going to accurately tell tenants what units they own when they know that they own units, somewhere in Rochester under an LLC, and you may not find out about it. There are some other exemptions, some other kinds of apartments that are not covered by good cause, and these are, um, for the most part, these are either very specialized or they're kind of common sense exemptions. So, if you're a subletter, the person you're subletting from might be covered by good cause, but you're not. If your housing is part of your employment, like you're the superintendent, or um, you are, a university professor who lives in faculty housing. That's not covered by good cause. If you're rent stabilized or rent controlled, you're not covered by good cause because rent stabilization and rent control are actually stronger than good cause. If you went from rent stabilized to good cause, that would actually be a downgrade. So So if you're rent stabilized, you don't need to worry about good cause. Also, what the law calls income restricted units, but maybe we better for us to think of them as subsidized units, units that are part of some kind of program, right? Like Mitchell-Lama or Section 8 or low-income housing tax credit. If you're in one of those units, you know it. If you don't know it, you're not in one of those units. And again, like rent stabilization, the reason good cause doesn't apply is because those housing units generally have better protections already. Units in co-op or condo buildings, units with a rent over 245% of the fair market rent. Um, if you can't remember 245% of fair market rent, just bear in mind that for a one bedroom, that's $6,000 a month, and a two bedroom is $6,700 a month. I'm going to guess that the people on this call are not over 245% of fair market rent. And then finally, the big one, um, units with a certificate of occupancy that was issued after 2009. So real quick, a certificate of occupancy, when a building is either when it's built or when it's been significantly renovated, the Department of Buildings has to inspect it and make sure that it's up to code. And if they find that it is, they issue a certificate of occupancy that says it's safe to live here. So if a building is built after 2009, or if it was renovated so significantly that like the number of units or the kinds of units in it changed, there's a new C of O and that building will not be covered by good cause. So good cause doesn't cover new buildings going forwards, and it doesn't cover buildings even going back 16 years. When did the good cause eviction law take effect? Most of the law took effect immediately when the law was passed on April 20th, 2024. And it affects any lease renewal or any rent increase or any court case that takes effect after that date. And just to be clear and to put a fine point on it, if your landlord sent you a renewal lease on April 1st, 2024, but the lease isn't supposed to start until May 1st, 2024, that lease is covered by good cause and it has to comply with good cause. And so for a number of leases that were offered right around the time the law passed, landlords should have actually retracted the lease, taken it back, changed the terms, changed the rent increase to make sure it complied with the law and sent it again. And I have seen, and I think there are a lot of leases that took effect after last spring, after April 20th, that don't comply with good cause. Um, Possibly because landlords just weren't up on the news and didn't know, or they knew about good cause but didn't understand when it applied, or because in bad faith they hoped that they knew that good cause would apply, but they hoped the tenant didn't. So, if you are covered by good cause and you had a lease renewal last spring, it's worth taking a look at that lease, seeing if it's covered by good cause and seeing if it is in keeping with good cause. So the rent increase shouldn't be more than that, 8.8%. And then one small thing I mentioned about how the landlord has to give notices, right? If they're saying you're not covered by good cause, they had to give you those notices. For technical reasons, that part of the law didn't kick in until last August. But all of the law is now in effect and has been since August 20th, 2024. Okay, I'm going to pause and just see that is a lot of information, and this is a law with a lot of intricate moving parts. It's not the most user-friendly law. So I'm going to pause and see if anybody has This point, just clarifying questions, right? About what we just went over, how the law works, who the law covers. Okay. I'm going to take that probably more as people are just so bewildered, they're not sure which questions to ask rather than the good cause eviction law immediately makes sense because it took me months to work this out, and I think I'm not the worst lawyer in the world. So it probably means it's not a very easy law to understand. Um, as a result of that, I mean, what that boils down to is there's still a lot of fighting that's going to go on in deciding how this law works, how it plays out, right? This is a law that we can be active in shaping. It's also a law that people aren't gonna, a lot of people will be covered by it, but not be able to use it, right? They either won't understand how it's supposed to apply. They won't be able to do the research on how many units their landlord owns. And, uh, a lot of this is going to take collective efforts, right? We're going to need to help each other on this one. Very first thing, a lot of people don't know that there is a good cause law or they don't know what's in it, right? We have to spread the word. Um, Second, it's really hard to research how many units your landlord owns. And it's a skill that we can all get good at and teach our neighbors and help our neighbors. And then finally, even if we understand the good cause law, um, you know, landlords are not going to enforce it themselves, right? We're going to have to go to them and say, this lease is not in keeping with good cause, and it should be. And these are the areas that we're most likely to get in fights over, right? I'll say again, the number of units actually owned by owners, right? Owners know that it's very hard for us to find out how many units they own statewide. Some of them, I'm sure, will be honest, and some of them will not be. Another area that we're likely to be in fights over for a long time is what kind of significant repairs should allow a landlord to increase the rent by more than the 8.8 or whatever the percentage is that year. And then finally, because a building could be covered by good cause, but then if the landlord renovates it enough and gets a new certificate of occupancy, it goes out of good cause. And that creates an incentive for landlords to do the kinds of renovations that they can get a new C of O for. And this is, for people who, have been around for the fights under rent stabilization, this probably sounds familiar. Landlords could, for a long time, get out of rent stabilization by spending money on renovations to the building. And they would. They would do that because even unnecessary renovations, even unnecessary upgrades, more than pay for themselves if you can get out of regulation. And that's going to be true again. These are some of the resources we have that are publicly available that can help us research how many units a landlord owns. People may be familiar with some of these, maybe not. Maybe you know some of them and not others. But HPD, the code enforcement agency, online has information about uh, every housing building in the city. You can search it by address. You can find out how many units are in the building, but most important, and what code violations there are in the building. But most important for our purposes here is you can find out information about the owner. They have to register every year with the name of the owner, whether that's a person or a company. They have to name at least one officer of the company, which is to say, at least one of the humans behind the company. right? And now those are great starting points. That may not be the full picture of everybody who's got a part of the ownership of the building, but it's a good starting place. Acris is a website that is run by, I think, the Department of Finance or the county clerks. I'm not sure which. But what it is every time a building is sold and there's a deed, the deed has to be recorded with the government, with the county clerk. Same with every time there's a mortgage. And all of that gets scanned and put online. You can go to this website and you can search by address and find out the whole history of a building, who's owned it, when did they change hands, when was there a mortgage, how much was the mortgage for, when did the mortgage get paid off. But most useful for our purposes is you can also search by name, right? So if you know your landlord's name, you can plug it in and just see right away whether there's any other buildings they own in the same name. And you can look that up and you can find out how many units it has. The Acris, once you get comfortable with it, also has another useful detail, which is if all you know about a building is that it's owned by an LLC, one of these anonymous corporations, you can still go in, and if you can find something like a mortgage, you can look at it and you'll see a human has to have signed that, right? LLCs can't sign documents. Humans sign documents. So you look at the mortgage or you look at something else that's recorded there, some other agreement, and you'll get somebody's name. Who owns what is a really useful tool developed by an organization called JustFix NYC. And what it does is it takes data from a whole bunch of different city government-run databases, and it puts them together so that if you type in a name or you type in an address, it'll show you every building in New York City, unfortunately not statewide, but every building in New York City that's associated with that name in any way. So this is the closest you can come in one stroke to seeing all the buildings your landlord owns, right? Um, it's not all the way there, though. A couple of reasons. One, it'll turn up buildings that maybe they owned in the past but don't own anymore. It'll turn up buildings that they may have some involvement in, but they're not an owner of. For example, they may work as a manager in another building, but they don't own it. Again, their name will come up. It's also, it has trouble with common names. So you can get false positives if you're looking for Joe Smith. But it gives you something to work with, right? It comes out really user-friendly. You'll see a map with flags all over the map. You can click on them, you can see what that building is, and you can look. And maybe when you look at it, you'll see, no, that's not my landlord after all, or that's my landlord, but he last owned it in 1992. But it gives you something to work with. So with these tools together, you can get a pretty good ways towards figuring out the units your landlord owns. And then the one final tool that's useful is the New York Secretary of State, which is who corporations get registered with, has a lookup, right? So any corporation that's incorporated in New York, you can look up their name and you get some basic information. Unfortunately, for LLCs, not very much information, right? You can get a mailing address. You can find out uh, when it was incorporated. But that can still be somewhat useful because at the very least, if you look up a number of LLCs and you see they've all got the same mailing address, then you know you're onto something. And then finally, there is another tool that is coming. doesn't exist yet. But the legislature passed a law about a year and a half ago called the LLC Transparency Act that would require owners of LLCs, the humans behind the company, to register their personal information with the state, right? So that it'll be these three people own the LLC and these are their addresses. Um, that will be fantastic, except that 6 months after the legislature passed that law, they passed another law that said the database won't be available to the public. It will be secret. Only the government can see it. Um, all is not lost, however, because there are some exceptions to the secrecy. For one thing, a judge can order information to be released from it, which means when we're in housing court, we can subpoena that information. We can ask a judge to sign a paper, send it to the Secretary of State, uh, and get the relevant information. We could say, give us all the information in the database regarding this LLC or this person, and we can get it that way. There are also some agencies that can get that data, some of which may be friendly to us. The Attorney General's office has access to the database, and they have a landlord-tenant division that uh, that works to try to enforce tenants' rights. So um, again, that law is still kind of a battleground, and we have some work to do to make it useful. But if we can get into that LLC, that would be the beginning and end of the research. That would be the database that you can type a name in, get everything they own, and be done. Um, okay. So again, a lot of talking, a lot of information. Um, if folks have any questions, I am happy to talk about it. And hold on one second. I have to rearrange my screen now that I've stopped sharing. I see a question in the chat. Give me one moment to read that. So the question is, what does this mean for people tenants in rent stabilized buildings? So first of all, buildings are not rent stabilized, only individual apartments are. So you might be rent stabilized, but some of your neighbors in the building may not be. And so if you're rent stabilized, the good cause law may affect your neighbors, right? There may be people in your building who until last April had no uh, had no protection whatsoever from no cause evictions, and now they do. And in fact, there was a building in East Harlem that our office was working with that where most of the tenants were on a rent strike. And there were two tenants who were not rent stabilized, and they couldn't participate in the rent strike because the landlord could retaliate against them and refuse to renew their leases. The law passed on April 20th, and on April 23rd, took us, I think there was a weekend in between. They joined the rent strike, right? So that's what it can mean. It can mean not only, extra protection for your neighbors, but also it's easier now for tenants in a building to stand together.